Chapter. Good morning.
Good morning, Your Honors. I'll start off with an apology getting over a cold, so my voice might be a little scratchy. Michael Lesage on behalf of TARRELL Moving and Storage. May it please the Court. Both sides, for different reasons, will say the facts of this case are relatively simple. TARRELL had a covered insurance claim. It was a moving and storage company, and some of its clients' goods were damaged. It did what it had done on its previous 29 claims with Stonington, hired a company, CFI, to inspect and repair the furniture. It initially believed there was no insurance coverage, so unlike the other claims, it retained counsel. Within several months, notice was given to Stonington. During this time, TARRELL had incurred breach of contract damages, specifically attorney's fees, and the CFI costs. The attorney's fees became breach of contract.
Are the attorney's fees an item of damages under the contract?
They are, Your Honor, and there are
Where
several.
Does the contract say that?
The contract does not say that. The Bevel case, for instance, does, and there are several other cases cited in the brief, that when a claim is tendered to an insurer and the insurer refuses to unconditionally defend, it breaches its obligations to.
Well, that's, I mean, but when was the claim tendered here to the insurance company? When did you tell them that they had this claim and that you wanted a defense?
They had notice of the claim by September 20th, which is in the interrogatories. A formal letter was sent to the insurance company October 30th, 2007, demanding they step forth and indemnify.
I guess I'm having a hard time understanding your theory that notice of a claim somehow equates with a demand for defense. People have, in companies, individuals have their own attorneys all the time. Until you tell the insurance company, we're asking you to defend under this clause of your insurance policy, why would they be?
Yeah, there's several reasons for that in this case. Number one, there's no duty under the insurance policy to tender the defense. It was an issue below. It remains an issue here.
I mean, you have the right to hire your own lawyer if you want to. I mean, there's nothing that says that simply because you have an insurance policy that gives you coverage that you're stuck with their defense of the claim. You can hire your own lawyer if you want to. And so I think you're supposed to at least say to the insurance carrier, you take over the defense, here's the claim. And when was that done in this particular case?
In this case, that date would be October 30th with the actual letter by certified mail.
And isn't that the date that the trial court found was the date that they were actually told?
It triggered the duty to.
Yeah, told to take this case over?
That was found to be the case by the trial court.
And you received fees from that particular date forward for your services until they actually took the case over, right?
In the underlying defense, that right. Is correct.
So why are you entitled to more fees than that?
In this case, the fees were essentially the fees incurred certainly during that time frame from October 30th forward were breach of contract damages.
Didn't they cure, assuming that there was a breach, it seems to me that at the very outside in January, I think it was January 11th of 08, they write and they say, we withdraw our reservation of rights and we will defend. It seems like if they had breached, that their breach was cured by that point and you would be entitled to damages up to that point. But I'm trying to understand why there were any fees incurred by your client from that point forward that they ought to be responsible for.
And Your Honor makes an excellent point. The defendant does contend that they confessed judgment in January of 2008. What they neglect to mention, either below or in their brief largely, are the CFI costs were also sought as an element of damages. Those continued to be sought more than a year later. They were paid by Stonington to CFI directly without informing the court, opposing counsel, or TARRELL that they'd been paid, And in the court below, Stonington had maintained it was not responsible for any costs whatsoever incurred before that October 30th, 2007 date. All of the CFI costs had been incurred before that date, and that fact was not disclosed, and it was accidentally only discovered by us when I got, before the mini-trial in this case, when I had to secure a records custodian from CFI to verify the records, and they managed to mention that, oh yes, we were actually paid on this claim. So the argument is they immediately confessed judgment, and they fully performed in January of 2008. That's just not the case. The CFI bills were unpaid. They were claimed. We continued.
So the costs are something different than your attorney's fees, right? I mean, those are separate items, aren't they?
We would argue they're both breach of contract damages.
Well, no, they're separate items, aren't they? I mean, we're talking about separate items of recovery here, costs and then your attorney's fees, right?
Now, those are underlying attorney's fees.
And the costs.
Yes, Your Honor.
And the trial court went through all the costs, and the court has discretion to determine what costs are going to be awarded and what aren't, right?
The court does have that discretion. It did not go through the CFI costs. They were not an issue by the time the court finally went to the final judgment, because as discussed, they had been, in fact, secretly paid by Stonington to CFI without disclosure to anyone. So, another interesting fact, Stonington talks about its numerous good deeds in this case. It states that in January 2008 it confessed judgment and fully performed. One of the other interesting arguments it made at that time is it sent a letter to myself saying, submit to us your attorney's fees and costs claimed. If there's a dispute, we'll notify you. Counsel for the Stonington then waited longer than 30 days and asserted that the fees were then untimely pursuant to Rule 1.525 and moved for summary judgment in terms of the fees on that basis, which really set the tenor of the whole litigation. When counsel says, do something, I'll take a look at it, notify you of a dispute, and then engages in gotcha games, I don't necessarily know they should be allowed to complain. Well, the litigation was long and drawn out after that point, and there's certainly a reason that was the case, and I would argue their conduct precipitated that. We continued to, and in fact did, recover breach of contract damages for our client right up until December of 2009. There was a dispute over entitlement to prejudgment interest on the underlying attorney's fees that the judge did rule were recoverable. That dispute continued right up until December 2010, right before the final hearing. And despite that fact, that benefits were recovered for the benefit of the client. No attorney's fees were awarded under Statute 627 for, I think, 18 months prior to that date, despite the benefit incurred to the client, the body of case law and confessions of judgment, Statute 627.428.
What are you seeking in fees after July 11th?
It would be the balance of whatever, essentially, we submitted our fees to the court. I think the fees were roughly $42,000 and change. There's an order on file that Stonington has not appealed, that they were not objecting to the rate or the number of hours. So you requested $42,000, and remind me, how much did you get awarded? The award was, I think, in the vicinity of $10,000, give or take.
Wasn't part of that $42,000 for fees that were incurred prior to what the court found to be the date of tender?
October 30th?
Yeah.
No portion of that, Your Honor.
So that was all after July 11th? So about $32,000 after July 11th?
It would have been, roughly. There was a discrepancy even at the hearing between the number of hours that Stonington conceded plaintiff was entitled to, and the court awarded some, I think, 12 to 15 hours fewer than that, despite the lack of any evidence to the contrary. And
what additional costs are you claiming? Not fees, costs. You're saying that the trial court should have awarded more costs. What were they again? What was the amount of that?
The most significant costs were court reporter fees and fees for deposition transcripts, which were in fact used. Mr. TARRELL, Mr. Wick's depositions were taken, and both transcripts were used. And the trial judge did not award even fees for those transcripts.
How much are the fees? Do you know right off the top of your head?
If Your Honor would like, I could probably.
Is that it? The court reporter fee and the fees for the deposition transcripts?
It would have been. We would have submitted it in our.
No, I mean, but what I'm trying to nail down the cost. You're saying that you were entitled to more costs, and you said court reporter fees and the deposition transcripts. Is there anything else?
It was your expert witness fee as well, correct?
Yes, that's another excellent issue. Thank you, Your Honor. In preparing for the hearing on attorney's fees, obviously in Florida, the current state of the law, as I understand it.
The trial court awarded something for your expert fee. You're just saying it just wasn't enough, right?
Given the complexity of the case and the fact that discovery was propounded to our expert, I believe the rule on discovery states that when you propound discovery to the opposing side's expert, you shall be responsible for the fee. Mr. Charpentier was kind enough to be our fee expert. He incurred 5.2 hours of his time in familiarizing himself with the file, responding to discovery, before the parties reached the in-court stipulation that Stonington was not contesting.
Okay, so we've got the court reporter, the deposition transcripts, and you're saying that the trial court didn't award enough for your expert witness fees. Is that basically all your costs that you're saying that you were not awarded that should have been?
That's certainly the majority, Your Honor.
Okay.
And does the panel have any additional questions at this time?
No, I don't think so.
Okay, if I can reserve my remaining time for rebuttal. Thank you.
May it please the Court, my name is Mark Tinker on behalf of Stonington Insurance Company. I think the main issues are the ones that were addressed this morning as far as the tender issue, the date of tender and the actual duty to tender, I think, as the panel has stated.
I certainly understand your argument there. What I don't understand is your argument that fees should stop on July 11th. Isn't it correct that in addition to the fees for the underlying defense provided after tender, that counsel will be entitled to fees for litigating entitlement to fees?
Yes, absolutely.
Okay. And on July 11th, you were arguing that he was not entitled to fees, and the court reserved on the issue of entitlement to fees with respect to the DEC action because you said it was unnecessary. So if that was still an ongoing issue after July 11th, and the fact that you said they didn't request fees on time so that they shouldn't be entitled to fees because of the lack of request, that is an outstanding issue. I just don't get why you say the fees close on July 11th when you're still arguing he's not entitled to certain aspects of it.
I think the confusion there is because of the language used, and especially the language that the judge used in the order. The argument that was being made as far as it was being unnecessary were portions of the litigation prior to that July 11th that was unnecessary. And I have the quote from that July 11th hearing, which is where Stonington originally challenged because of the untimeliness of the motion. The judge denied it, and at that hearing, that issue came up, and counsel said the necessity of attorney's fees and costs is separate from entitlement. It goes to whether or not the plaintiff should be reimbursed for those amounts, and he's talking about unnecessary acts that took place in that time frame.
I guess if that's the argument, then why doesn't he need an expert to testify that these fees were reasonable and necessary? You're saying he doesn't need an expert, but these fees are not reasonable. That doesn't make sense either, really.
Well, it was saying what was reasonable in that time frame as far as any litigation, I guess, that was necessarily done. And I think that's something that expert testimony isn't needed for, where the judge could look at it and say, you know, this motion for rehearing and that motion for rehearing and filing for fees.
Don't fee experts typically testify as to the reasonableness of the rate and the reasonableness of the hours, which generally includes the reasonableness of the work that was done. This work was reasonably necessary for this litigation. Isn't that typically the...
It is.
Okay.
It is, and I think when you look at, that was an argument that was made, and we conceded that the time that was spent on the listed tasks was appropriate, and I think what we need to look at, if that's an issue that's troubling you, is the argument was made, well, Judge, find some of those unnecessary and reduce them, and the judge did not do that. So to the extent that that was error, I know it came up in the prior argument about the two-issue rule, you're not just looking for error, you're looking for harmful error. The judge didn't do it, she didn't make any reductions. So I think to that extent the issue is a moot point. But the argument was made was not, they're not entitled to fees. We at all times agreed. They're entitled to their fees for filing the deck action and for the portion of time when we contested the timeliness of the motion.
So
but at
what
that
are you
point,
saying the trial judge took under advisement with respect to the necessity of work after July 11th?
The judge took under advisement whether issues from the filing of a deck action through July 11th, when Stonington conceded entitlement and was told that they lose on their 1.525 motion. The argument was made, Judge, you can look at some of the work that was done in there, and I think has been unnecessary because in Stonington's view, there was a lot of churning that was done throughout this litigation. And the judge effectively denied that, so I think the argument was made, Judge, you can remove some of this. The judge said no, but that doesn't change the fact that entitlement was conceded at the July 11th hearing. Counsel said, and I just read you the quote, he said that's separate from entitlement. We want you to look at the amounts and reserve as to that and say some of this work was unnecessary, but we agree that they're entitled to their fees. So now we're just looking at amounts. One other issue that was raised.
What about the costs? He narrowed it down to the court reporter, the deposition transcripts, and then he says that the expert witness didn't get paid enough. And he says the depositions were used at in the hearing.
Well, I think there's two issues on that, and one of the big things is costs are prevailing party costs, and they're made to go for things that were, I believe, meant to reduce. The judge can reduce things that were unnecessary, and I think this goes to the same thing where we have all of these depositions and all of these transcripts that were taken, go to the hearing, and the judge ruled in Stonington's favor on everything, said, well, no, the date of tender is exactly when you said it is. The date you conceded entitlement is exactly when you said it is. So I think to the extent that all of this work was done and all of these costs were incurred, many were unnecessary, and then TARRELL did not prevail on any of those issues. I think outside of that, the one thing that I was the counsel brought up was entitlement to prejudgment interest, saying that was an issue. That's incorrect. The prejudgment interest, again, Stonington agreed they're entitled to prejudgment interest on these underlying fees that they incurred defending themselves before Stonington took over. But the issue was we can't calculate what that interest is until we got the date of tender. So that issue remained until we had the hearing. The judge said, you're right on the date of tender. Now we know how to calculate interest, and it was paid.
What about the CFI payment?
Those, again, that's something separate. The CFI payment is part of underlying damages. So those, as soon as...
I understand, but their contention is that we needed to continue the litigation because they had incurred the payment to CFI that you should have paid. Apparently you paid it, and my guess is probably even you didn't know that it had been paid. It's probably somebody at the carrier paid it and failed to inform anyone of that. But in any event, everybody's apparently operating under the assumption that this bill is still outstanding and the litigation is churning away.
I believe that the issue there, again, as I'm saying, those are underlying damages. So at the point when Stonington, originally after this was filed, and said, we agree, we're going to provide you coverage, indemnity protection, and a defense to the underlying claim, that's part of the indemnity protection that Stonington conceded. They said, we're going to pay those damages, because if you look at the insuring agreement, it says any damages you incur and related costs are part of what's insured. So that was conceded right away, said we're going to pay those. As part of the underlying, the peak litigation kept going on, but that doesn't mean that the deck action needs to keep going too, because not everything has been resolved over there, but that peak litigation was eventually resolved with retained counsel, the CFI costs were resolved, all of those damages were paid as Stonington agreed it would do at the outset of the litigation.
How did you communicate to them that you had paid the CFI claim?
Well, I think my understanding, it's not very clear in the record, but my understanding is as you as you stated, that I believe it was done between Stonington and a CFI employee, and none of the parties to this, well, the attorneys to this litigation and TARRELL were not involved in it. It was just something that was negotiated between an adjuster and a CFI billing manager. That's what I gleaned from the record. So, I mean, I think to the extent that everybody was unaware it had occurred, that doesn't change the legal effect of it, that Stonington had agreed, we're going to pay all of those damages and your costs associated, because that's under the insuring agreement.
I'm not sure that I understand, and maybe maybe I just don't have a good enough grasp on the timing of things here. On the one hand, you say that you conceded their entitlement to attorney's fees for the deck action, but then at the same time you argued that their request for fees was untimely under 1.525. Help me understand those two seemingly conflicting positions.
Absolutely. When the lawsuit was originally filed, Stonington conceded the underlying claim, said, yes, we'll provide you with coverage and defense, and originally said, and we agree you get your fees for this deck action. After 30 days passed, Stonington thought, well, our original concession is a judgment. They didn't file a timely motion under 1.525, so maybe you're not entitled, and re-challenged it. We went to a hearing, and
On July 11th.
On July 11th, the judge said, no, they are entitled, and Stonington conceded. So now we've got that entire gap. We agree that they're entitled to them from the filing of the deck action all the way until we finally gave up. So Stonington made a little mistake in the air in the middle of trying to challenge.
So you said you get your fees, we'll pay your reasonable fees, and then when they don't submit the bill to you within 30 days, you say, oh, out of luck.
Right, and we agree that the judge said we're wrong. And
do you have a sense that doesn't really pass the smell test?
I agree, and the judge said we're wrong, and I haven't challenged that on appeal. I mean, they get that entire chunk, notwithstanding, that we said in the middle, no, you don't, yes, you do, but we agree now. They get the whole thing. The judge told us we're wrong. I don't disagree with you on that.
And I guess I'm still struggling. I mean, you explained it, it made sense, but I'm still struggling with the fact that at the July 11th hearing, you were still saying, no, they don't get the fees for filing the deck action because it was unnecessary. And the trial judge said, well, you may be right about that. And when was that issue finally resolved?
Well, that's where I disagree with you.
July 11th.
I disagree with you on that, because that's the quote that I read to you. Counsel didn't say you're not entitled to anything for filing this deck action. He said that's separate from entitlement. We're talking about the amounts, any amount of work that was unnecessary in that window. We agree you're entitled to that.
Read the quote again from the hearing.
No, Your Honor, we raised that in the motion to preserve it, but really the necessity of attorney's fees and costs is separate from entitlement. It really goes to whether or not the plaintiff should be reimbursed for the amounts. And later on, counsel went through and he said, plaintiff wants to argue that somehow that we were contesting entitlement to attorney's fees. All that recognizes exactly what the Florida Supreme Court recognized in the Patients Guaranteed Fund versus Roe, that the court may amend the lodestar up or down, and it does say down based upon the results obtained and the necessity of the lawsuit. There's no reason why this court can't take the lodestar, and as we're conceding the hours and $200 an hour rate, and move it down based upon the necessity of what's taken place in this case.
Right, but wasn't the argument really that with respect to the deck action, the amount should be zero?
No, it was not.
For the deck action, because the deck action, the way the trial judge said it, it sounds like the issue under consideration was whether the deck action itself was at all necessary.
And I agree with you. That's the way I think the confusion comes from the wording of that one written order. I believe it was titled the corrective order, is the wording that the judge put in there.
And what did you do in response to clarify that no, we concede that the deck action was necessary, they're entitled to fees as to that, but we have some question as to whether the amount requested for filing the deck action was reasonable? That
was the argument that was made when TARRELL filed a new motion for fees, saying you're contesting this, and that went to a hearing. That was the argument, part of the argument, the second part that I just read to you. I'm sorry?
When was that hearing?
I don't believe I have the date in front of me. I can find it for the court if you need it.
That was prior to July 11th, wasn't it?
The original quote that I read to you was at July 11th, where...
No, I mean the before, what we're talking about now.
No, it was after. Was
that?
No, that was after the judge issued.
Okay.
The original one that I read to you was at July 11th, where he said this is separate from entitlement. We're only talking about amount.
But the hearing that you're talking about now was before July 11th, right? Where you're saying you're trying to find that date now?
No, that's after
No,
July.
after.
Oh, that's after.
After the
okay.
judge entered the order.
There's so many hearings in this case, it's hard to keep track of all of them.
Absolutely.
All right.
That was on a January 20th, 2009 hearing. So
a
after
year and
the
a half
judge...
later?
After the judge, well, that was the next hearing that came up. After the judge had entered that ruling, there was more litigation that occurred, and the issue came up because the issue of fees came up again in the argument about necessity of litigation, and that's where counsel for Stonington again clarified, we're not talking about saying they're not entitled to anything. We're talking about adjusting the lodestar down based upon the necessity of what's gone on in this case, was his quote. And that's...
But you're also saying you don't need an expert to testify that your actions were reasonable and necessary.
I understand your concerns there, but again, the judge didn't adjust it down. So there was no harm made from trying to tell them you don't need an expert. That didn't harm anyone. I understand your concern there, and I agree with you that to the extent that that was an issue, that expert testimony probably would have been required, but it didn't. The judge didn't rule on it. The judge appropriately said, here's where you conceded the entitlement. You get all of your fees for that portion of litigation. After that, we've just been talking about how much, and we know that's not compensable. Unless the court has any further questions, I'll yield my time.
All right, sir, thank you.
Thank you.
We've got about 6 minutes left.
Thank you, Your Honor. Voice is not cooperating today. There are some issues I would like to clarify. Initially, the CFI bills. The supposed confession of judgment or the partial confession occurred in January. The CFI bills were not paid at that time. They weren't paid in February. They weren't paid in March. They were actually paid in September of 2008, which was discovered by us, I think, in May of 2009 accidentally. And the dates for that are set forth in my brief and amended brief. The CFI bills and the underlying attorney's fees below at volume 2.
Wasn't this case really about fees? Really the CFI bill. They said that they were going to pay all the costs, and they even said they were going to pay your fee. They just wanted to know how much. Wasn't this case really about fees? That's it, isn't it?
At that time, it was about CFI. We moved to tax that.
They said we're going to pay everything, and you sent your file over to them, and you said send me a check for my attorney's fees, and they said we're going to pay your fees, we're going to pay the cost, we just want to determine how much. And you wanted your check right away, and they said no, we want to determine whether you're entitled to this full amount or whether you're entitled to something less. And that's what generated all this. It was the fees, isn't that correct?
The fees together with we were seeking recovery of the CFI bills. It's in our initial amended motion for attorney's fees, which was filed in April of 2008. So that was an element of damage we were seeking. We were not informed it was paid. That was directly for the client's benefit because the client was liable for that.
How did they respond when you filed your motion for fees? You said in April of 2008?
Yes.
What was their response to that?
I believe it was their motion for partial summary judgment that TARRELL was entitled to no fees, no costs on anything.
Based upon your untimeliness?
That was one of their arguments. They had 3 arguments in their initial.
In 2008, that was their argument?
Yes, Your Honor. That was
the run-up to what ultimately happens at the July 11 hearing.
Oh, that's the July.
Is that correct?
yes.
You file a motion for fees. They file a motion for summary judgment saying you're not entitled to fees because you're untimely and your fees were too much, and I forget what else they said. And then on July 11th of 2008, the judge says you're entitled to fees.
No, Your Honor. There was no such ruling made until certainly not at the hearing in the summer. I believe it was the date of tender that was determined. The ruling on entitlement, Stonington's continued to maintain there was such a ruling. When
did they concede when did the court determine or when did they concede your entitlement to fees? And I guess the issue was from what date?
The hearing in the summer determined, I guess, the date of tender. I think that's
the July 11th hearing.
In 2009. Then there were some motions in limine.
That was 2008. July 11th, 2008, the trial judge says, okay, I had got the date of tender, and they said we're not contesting anything except the trial judge determined that the necessity of the deck action was still an issue. That's result of the July 11th hearing.
And at that initial hearing in 2008, the first day, I guess, was determined of reimbursement for the underlying attorney's fees. And then it would have been, I think, summer of 2009, before the motions in limine, or with the motions in limine, that was when the last date for reimbursement was determined. The facts are somewhat confusing. I've laid them out as best I can in my briefs. A couple other points I would like to make. Stonington has stated, Your Honors, this morning that the prejudgment interest on the underlying attorney's fees was not at issue. They immediately agreed. I would ask Your Honors to look in my briefs, check the record. The statement's blatantly false. Letters went counsel likely doesn't know. Letters did go back and forth. Stonington saying, no, you're not entitled to prejudgment interest. I sent the same letter to them several times. See the Argonaut case? Yes, we are. And in December of, I believe it was 2009, at the end of this litigation, they paid that. Also in my briefs, you will see there are numerous references that Stonington continued to make throughout this litigation. The deck action was unnecessary. I'll take them at their word for it. It's all I can do.
I guess all this conversation that we're having goes back to my point. Really, this was about fees, wasn't it? I mean, whether CFI was paid or not was really not your primary concern. You didn't spend a lot of time trying to recover that bill, did you? It was mostly about the fees, wasn't it?
I spent the same time. I was going for damages. It was an element of damages that I was seeking to recover for my client.
All right, sir. Well, thank you. You've exhausted your time.
Thank you.
Thank you both.